Good morning. We are here for oral argument on A&P Ranch Limited versus Cochise County et al. It's our number CV-25-0217. Each side, of course, has 20 minutes. You may keep whatever time you wish for rebuttal, but you have to keep your time yourself. Please proceed.
Thank you and good morning. My name is Jim Sousa. I'm with the Deacon Cini McDonald Law Firm in Tucson. I'm joined at council table by Cindy Schmidt with the firm, and then Assistant Attorney General Kim Seigan, who will be representing the Department of Revenue and address any questions you have on the department's manual, since they're the ones that created it.
Are you dividing your time here, or how is it?
We're going to do the best we can. I'm going to do the county's heavy lifting, and then if you have questions on the manual, Ms. Seigan will do that. And then we'll try to reserve a few minutes, maybe 3, 4, 5 for rebuttal time. I'd also like to recognize the presence of the elected Cochise County Assessor Philip Leindecker here with us today. Madam Chief Justice, may it please the court. This case looks a lot like the Chalmers decision from 2025. And in getting ready for this case, and I'm the new person, I looked at Chalmers and said, I think we have exactly the same problem. In the Chalmers decision, the Court of Appeals reached a decision focusing on one specific statute, but failed to look at the context of where that statute was located. In fact, this court pointed out that the context is always relevant to statutory interpretation. If a provision is part of a broader statutory scheme, context can tell us the overall objective. Judge Perkins wrote Chalmers and the lower court decision here. Judge Perkins is an excellent judge. That's my experience. I wasn't involved in lower cases, but it seems like we have the same issue here. We laser focused on 13-101, and we didn't take a step back and say, what's the overall objective here? And in the earlier argument this morning, I believe you, Chief Justice, said, we're not here to tell the legislature how to rewrite a statute. You don't have to tell them how to rewrite a statute here. We've had these statutes in place for over 50 years, and they work very well. And the statutes all begin with the general proposition, and I'm just going to say 13054 because it's 42, everything's coming from 42. That is the assessor's job every single year to determine all the full cash value for each piece of real property in the county. And it's been that way for decades. And we then go on to define full cash value to mean market value determined using standard appraisal practices. If those were the only two statutes on the books, then this is real straightforward. The assessor knows how to do standard appraisal practices. He knows that real property is land and improvements. And his job then is to go out every single year and determine a value, send you the postcard in February, and you say, there you go. We've done it for another year and we'll move on. That's the general rule. However, we have specific carve-outs from the general rule. And one of the important carve-outs is for agricultural property. Another carve-out is for golf courses. Another carve-out is for common areas. We do not use standard appraisal techniques when it comes to those. And it's a specific legislative choice. For our friends in the agricultural industry, we want to have a very low property tax bill. This is important because agriculture carries Arizona. And how do we effectuate that? We have a specific statute that we go to do that. But before we get to the specific statute, you have to start with, are you in fact agricultural property? One of the interesting things about this case is you need 10 acres of fruit trees to be agricultural property. That's in 12151. What if you have 9? The answer is, then the exception doesn't apply. You have standard appraisal techniques for the improvements, and you have standard appraisal techniques for the land. You add the two numbers together, that's your parcel value. But then you get the magical 10th acre. Now you have agricultural property. And now the improvements have no change, but the land has a huge change. And at this point, we go to the specific statute, 13101, and it tells us that we have to use an income approach to value. Importantly here, and the Court of Appeals missed this, this isn't the income from being the farmer and the money you make from being a farmer. This is the income from the landowner who rents out the property to the farmer.
But doesn't it, I gave that a lot of thought. The rental value for the prior 5 years. It's supposed to be comparable, hopefully in the vicinity. And when it gets into comparable, well, are you comparing vacant land for all of the, say you have a vineyard, are you then comparing the land under the vineyard to 5 years worth of other vacant agricultural land, which I guess could be anything under that definition? Or what's wrong with comparing vineyards to vineyards, which
Perfect.
would include, the value seems, more comparable.
Perfect, because none will ever exist. That's the problem. You don't spend the money to plant 2,000 trees on 40 acres, nurture them for 7 years before they produce their first nut, or you don't plant vineyards and nurture them for many years before they produce their first grape, and then lease it out to somebody else. Nor does somebody come in and say, I've done all the work, you go run the farm, and I'll just collect rent. It never happens. And so in a perfect world, we'd have vineyards that are leased out, fully ready to go and producing, and then we'd have a perfect rate. We don't have that world. What we have is vacant croplands that get irrigated. We know what the lease rate is, and then we calculate a land value based on it. There's no allegation in the complaint that the $1,800 per acre that was done that way was done incorrectly. Period. Let me tell you the benefit that we get. I'd ask you to look at the Stewart Title and Trust case from
Wait, before you go away from appraisals.
But I wanted to.
You said it never happens.
It never.
And I'll believe you on that because I don't know. But don't appraisers all the time have like artificial type of sets of circumstances where they can say, somehow come to a valuation of, well, what would it rent for? If someone wanted to rent this out, this whole vineyard,
Yep.
what would they come up with?
If only that were true. The unfortunate aspect of this is 13101 has 13102. And 13102 says the only information the assessor gets, I'm not going to wave my pencil at you, the only information the assessor gets is from this lease abstract that the landowner fills out and says, I'm leasing 40 acres of land, this is the amount that I'm getting for it. They take all those lease abstracts together, and they then say, what's the value going to be in the county for every single ag property in the county, no matter whether you're putting pecans, cotton, alfalfa, everybody's going to get that same value because that's the only information that we have.
Okay, if that is so, then where in the statutes does it say that then you will separately value those permanent crops to add them into this, the rental, the income approach?
Because the 13054 tells the assessor to determine a full cash value for all land and improvements in the county. The general rule stands unless a carve-out exists. A carve-out exists solely for agricultural land that meets the definition of agricultural property. Now, that's important, and that's what the Court of Appeals missed. If you become agricultural property, you get the carve-out. If you don't, the 9 acres of orange trees, there is no carve-out. Standard appraisal techniques, land and improvements, general rule. So, Stewart Title, $4.5 million purchase price for land, assessor value $2.2 million. Property owner who just bought the property sues and says, this is ag property. The value is $3,500. And the assessor says, if it's ag property, you're right. That's what the formula produces. If you're doing the math, 99.8% discount from the assessor's value to ag property. This is the intended legislative benefit solely for agricultural property, and that's for the land.
So what if what if it was not an aggregate of 10 or more acres with a permanent crop? Say it was an aggregate of 8 acres. And it's not going to be cropland then, and it's not going to fall under the 12151 definition.
Yep.
So are we just talking it's not going to qualify for agricultural
Exactly
land?
the point I'm making. You have to be agricultural property to get the special land value. 9 acres of orange trees doesn't get you there. Get the extra acre. Plant the orange trees, have 10, be ag property, 99.8% discount. This is worth the effort. So as a result, that's how the statutes work. And so that's the beauty of this system. We have a general rule which has been in place for 50, 60 years. Go figure out all the values, standard appraisal techniques, land improvements, unless it's a common area. Well, if it's a common area and it meets the definition, then it's just $1,000 a parcel. Again, a carve out. What if it's not a common area? Same general rule, land and improvements, standard appraisal techniques. So when they put in a carve out, they make specific tests you have to meet. Not a close is enough, you have to meet it. And here they met it. And because they met it, they got the special rule. A reduced land value at $1,800 per acre. The next point I'd like to make is the manual that the Department of Revenue produced has told the assessors for 40 years, when you're doing standard appraisal techniques, look at all the barns and everything else, use that, add those as improvement values, and then put $20 per tree. That manual was antiquated. It was little Cochise County in southeast part of the state that said, guys, this is from 1983. We got to do something here. And the Department of Revenue said, you know what? We're not going to go do another study, figure this out. Use standard appraisal techniques, find out what an orange tree is worth, and then add that as an improvement, just like you added an improvement for the barns, the sheds, the fences, everything else.
Is the standard appraisal of the orange tree in your example done like the orange tree sitting at the nursery unplanted or
Nope.
already part of the land?
This is a fully mature orange tree that's producing crops. And so they determined that one of those trees is worth $250. The taxpayers in their complaint do not say $250 is higher than the fair market value of a fully producing orange tree. That's important. They never make that argument. Their argument is not go back to $20 because we really like that. We think it should be $0. And you should never have a value for that. And that's a fundamental error in understanding our tax law. By default, if there's not a special carve out, the answer is standard appraisal techniques to determine a value for land and improvements for the entire parcel. Let me use Yuma as an example. If you're driving into Yuma, heading to California, on your right, on your left, agricultural land, right, left, in between, sheds, everything, wells, ditches, everything. Very easy. What's vacant land worth? It's desert. What happens if it's ag land? Well, now we have a special formula. But all those other improvements were added by the farmer. And because they were, they got the Yuma County assessor to put a full cash value using standard appraisal techniques. That's what the general rule is, and that's what they're supposed to do. Here's the final part that I think is interesting. The taxpayers bash the manual that the Department of Revenue produced. They bash the department. But if the manual didn't exist at all, the assessor would have calculated the same value for each parcel. They would use standard appraisal techniques for the trees, the barns, everything else, and they would have used the land valuation statute for the land and would have arrived at exactly the same number.
Where in the statute does it indicate that permanent crops are considered improvements? I think that was a question the chief asked a few minutes ago, and I haven't heard an answer.
And the answer is nowhere, and this is why we win. Because we don't have a carve out for permanent crops. What we have is all improvements are revalued by the assessor using standard appraisal techniques. The only time that rule changes is if there's a carve out. If in the agricultural statute it said permanent crops get a $300 per tree value or anything else, different answer. Carve out now exists. If there is no carve out, the general always prevails. And so when the taxpayers bring up there's nothing in the statute that says permanent crops, there's nothing in the statute that says this, which is why we win. Because the general rule then applies that we use standard appraisal techniques.
And what's the general rule? Is that under the
13054?
You said 13054?
051, I apologize. I got to read my own notes.
051. I'm
Yeah,
sorry.
13051 is the assessor's responsibility to determine the full cash value of real property. 13101 defines full cash value as the market value using standard appraisal techniques, and real property is land and improvements. And so if those are the only statutes we have, the assessor does their job using standard appraisal techniques for every piece of dirt inside the county. But when there's a carve out, you have to go down the carve out road. And that's what they did. Your Honor, I'm going to reserve the rest of my time. If you have any questions on the department's manual, Ms. Saigan is here to answer that. If not, then we'll just reserve the rest of our time.
Okay,
Thank you so much.
thank you. I guess you're asking us if we have any questions on the manual. Any questions on the manual? No questions on the manual. So, all right, you're clear. It's been all night preparing about the manual. No manual. Okay. All righty, Mr. Mooney.
Thank you, Your Honor. For the record, my name is Paul Mooney. I'm here at council table with my partner, Paul Moore. We represent the 16 plaintiffs in this case, all of whom are farmers in Cochise County. They raise pistachios, pecans, or pecans if you're from the South, and wine grapes.
Did you bring any of them with you?
Well, I'm not from the South, so may it please the court. The issue before you has actually been misstated and misrepresented, at least in terms of the law. Let's start at the beginning. All property in Arizona is subject to taxation as provided by law. The definition that is applied is called full cash value. Full cash value is defined in ARS 4211-001 subsection 6 as follows. Full cash value for property tax purposes means the value determined as prescribed by statute, period. Then it says if a statutory method is not prescribed, full cash value is synonymous with market value, which means the value calculated according to standard appraisal methods and techniques. We just flipped that a minute ago. Mr. Souza repeatedly stated that the starting point is standard appraisal methods and techniques, and assessors all know how to do that. Yeah, they do, but they don't do that if there's a statutory method prescribed. That's TRICO, this court's decision in TRICO. Interestingly, Justice Feldman, who was not yet Chief Justice, wrote a concurring opinion in that case. It's quite humorous, in which he said, the legislature has the power to define a horse as a camel and to tax it as such. The legislative prerogative here is under Article 9, Section 11 of the Constitution. That's also discussed in TRICO. We defer to the legislature's judgment regarding how to value all property in the state. In the case of agricultural property, since at least 1967, the law has been that agricultural property gets a favorable value. We do that for policy reasons, one of which is we all need to eat. And so production of food in its various forms is important, so we want to make sure that people involved in the business of agriculture and are devoting their land and property to the production of agricultural goods and commodities, whether they're cotton or crops that we eat or cattle, by the way, all three of which are in the state seal, sitting in most courts, it's sitting above you, but it's not there today. It's in the Superior Court building, and I've argued many cases there, and I've always intrigued by the fact that we have those three important industries, which are the essence of what our state was founded on. So the legislature, in recognition of that, in 1967, adopted a favorable valuation formula that said, look, we're not going to tax people out of their property just because of urban spread and because land becomes worth more over time. That's the Burns versus Herberger case. You ratified that rule in Golder years later. The law has been established for a long time. It's very clear. But the premise is full cash value is the value determined as prescribed by statute. So let's get back to the issue this case presented, which is this. These properties are all agricultural properties. There's no dispute about that. They stipulated to it. These cases were presented on cross motions for summary judgment in the tax court. Everyone agreed they're agricultural properties. They fall within the definition. There are no 9-acre cropland properties here. They're all more than 10 acres. They're all legitimate agricultural real property as defined by 42-12-151, subsection 2. So they qualify. The Court of Appeals correctly analyzed that framework and said, look, that's the starting point. We don't have any dispute here about classification. We know what these properties are. They all consist of land used for agricultural purposes. But we have these three odd terms that appear in different parts of the statute. First, we define property as property used for agricultural purposes. That seems self-evident. But then in the next statute, 12-151, we define it as agricultural real property. By the way, the only place in the statutes where that phrase appears. And then we get over to the valuation statute where we say land used for agricultural purposes or agricultural property, another phrase, is valued this way. And then the defendants in this case, when we were below, they wanted to argue that, well, you have to read subsection A of that 13-101 in isolation. In fact, we like the heading to that section too, because it says land.
Well, one of the things that, this to me is a confusing scheme because of the different use of terminology, as you mentioned.
It is.
So really trying to figure this out, one of the things that Mr. Sousa said was, if you look at 42-13-101 and you use the income approach, that it's not possible to do an income approach with the vineyard, the orchard, whatever, because no one rents those.
I'm glad you brought that up.
So is that, can you maybe address
Sure. There's
that?
no evidence in the record that supports him at all. None. In fact, if he'd bothered to read the record, he would know that I deposed Mr. Leyendecker, the assessor, and Mr. Leyendecker testified that he had two leases that he considered. He rejected them because he felt they were related party transactions. It was a father and a son. I think in one instance it was two corporations that were related, a subsidiary and a parent. And he said, no, I can't use those. I said, well, did you look at them? Well, yeah, I looked at them. I said, what'd they show? Well, they showed that the value was slightly higher. I said, define slightly. He told me like maybe $500 as far as I recall. Well, in the old days, when there wasn't any fight about this, the table in the back of the DOR's manual said $600 for nut trees, $100 for grapevines. By the way, he didn't have any vineyards. He didn't have any leases on vineyards, but he had two in Cochise County on leases of nut trees.
Well, I suppose, the reason that he brought it up, the reason I asked the question is if that is so, that generally, maybe with some exceptions here and there, you're not going to have comparable orchards, vineyards, whatever, for rental property. Is that an indication of legislative intent that truly under 13-101, they really meant just the land?
No, it does not. And here's why. Because the whole premise of the agricultural valuation process was back in 1967 when they were deciding how to value agricultural property. They said, look, we want to know what agricultural property rents for. And so we're going to prescribe this standard. And it's been largely unchanged since 1967. It's been renumbered a couple of times. But the reality is it's the same formula. And basically what it said was we want to go out and survey and look at leases. By the way, most agricultural property is not leased. That's true of field crops as well as permanent crops. The simple fact is the fact that it's not leased doesn't mean you don't value it using the statute. Even they agree you value cropland at that method. Why? Because they have some leases at least that they look at every year. And in fact, by law, to be qualified as an agricultural property, you have to submit lease data to the assessor on a regular basis. DOR also has the authority because they publish these manuals and they go out and survey the state as a whole. They go and survey other states and surrounding states to see what's happening. So that they had a table C in the back of the manual for 40 years. And everybody was using it. And everybody says, well, why didn't you ever repeal it? Nobody cared. You know what the tax consequence of a $600 value is on a cropland per acre? It's dollars and cents. Nobody's going to pay the money to fight that case. But when the assessor comes along, as he did in this case, and says, no, I'm jacking the values up from $600 to $12,000 an acre for nut trees, and I'm jacking the value of vineyards up from $100 an acre to $8,000 an acre, gee, surprise, surprise, somebody noticed.
Just to be clear, so I have it in my mind correctly. So your argument is that the valuation should be for both the permanent crops and the land together. You would look at, would it be simply comparable agricultural land of any ilk?
Correct. They don't differentiate.
It doesn't have to be
We
you know,
got that admission out
okay.
of DOR and the county when we deposed the folks involved who compiled the manual. We did 30B6 depositions of 2 people from DOR about that. They had no evidence whatsoever to support what they were doing. They never did. But the simple fact is they were doing it because they're supposed to promulgate manuals. And they did. And we know that the assessor has data because that's required to be submitted. And so they know they do have some leases in every jurisdiction in the state. They have agricultural leases that they can look at. So they can look and say, okay, what is agricultural land? Land devoted to agricultural purposes. Cropland, whether that cropland is permanent or field crops, doesn't matter. The crop is irrelevant.
It could be anything under the definition of agricultural property,
Correct.
you know, processing things, even the algae, something that I didn't know we had.
It could. They have some slightly different rules that apply to things like dairies and things that are more what we would think of as industrial type properties, citrus processing plants. And there's a case in Arizona called Central Citrus where that issue was litigated. There's a cotton case involving a cotton gin. Those are clearly treated slightly differently. But the agricultural land, the land that's producing agricultural crops or commodities, whether it's cotton, vegetables, whatever it is, irrespective of the nature of the crop or the plant that it grows on.
Okay,
but it gets valued the same.
But it includes the crop in the valuation.
It does. And the land includes the crop because the common law of this country for years has said land is defined as including trees and rocks and all the other things that are located on the land.
But not barns.
Not barns, no. No, in fact, that's an interesting, I found something after I read their petitions because they've raised that issue in their petitions for review. And I actually went back, I didn't see this till yesterday. I was rereading the tax court's ruling. And in the middle of the second page of that ruling, the tax court judge says this: the assessor used a tree value of $12,000 per acre and added that to the statutory land value of $1,800 per acre, which was calculated under the statute, and to the value of any buildings/structures to determine the full cash value. And the citation to that is the county's statement of facts in support of its motion for summary judgment, paragraph 5. That's right out of the tax court's ruling. So this case was never about buildings. It's never been about buildings. And so, Justice Montgomery, to answer your question, buildings have always been treated as separate things. And in fact, the parcels that we appealed are agricultural land parcels that produce crops. They're not parcels that have storage buildings for harvesting equipment or storage buildings for hay or storage buildings for anything else or silos or any of that sort of thing. Those are all kinds of things that might exist, but when they do, the assessor values them completely separately.
So let me ask you a question to put a finer point on it then. So if I have the requisite number of acres for agricultural land, but here's my question, then that particular land that's being valued will not have other improvements on it. If we consider permanent crops as part of the land, other buildings, other structures are going to be on other parts of the farm or the ranch. It's not going to be on.
It may or it may not. I have a small ranch up north that we lease to a rancher who grazes cattle on a large part of it. We also have a large conservation easement that is limited to that use, so the assessor values it that way. But interestingly, some of the parcels where I have a house, those actually get split to the point where this parcel's the same, but the value of the land underlying that parcel, part of it is valued as grazing land, part of it is valued as my house. And so, yeah, that can be done. And so I don't want to say something out of school here and say that there's some evidence that it's always that way, because I don't think that's a fair statement. What I will say is that the assessors know how to deal with that problem when it comes up. And my only point is they value buildings differently. Barns, silos, those kinds of things, fencing, that's all improvements to the land that gets valued based typically on its replacement cost, new less depreciation. So that's the method.
I asked Mr. Souza where in the statutory scheme for agricultural real property can we find the legislature's intent to create permanent crops as
there isn't one. You're
okay, and as improvements, and his response was there isn't one. He acknowledged that.
Correct.
And he said that's
He's
why
right. He's right.
That's why they win. What's your response to that?
That's why they lose, in all candor, because in effect what we have here is a situation where Mr. Souza's theory of the world is that permanent crops are improvements and they're separate. The Court of Appeals never reached that issue. The Court of Appeals went out of its way to say we don't even need to reach that issue to decide this case. We're going to reach it by looking at the statutory construction rules. And the statutory construction rules tell us I've got to construe all of these statutes together, make sense of them, harmonize them in pari materia, whatever term you want to use. And they did that. And the court said, all these out-of-state cases that they cite, which they also did cite, some of them, in fact, many of them, have separate statutes or regulations that are on the books that say you have to value orchards differently. We don't have that here. And if they want to go to the legislature and change the law, fine. This is a legislative prerogative. It's not for the courts to decide.
The trouble I'm having conceptually within operation of the statute under 12-151, we have cropland, and then in the next subsection we have permanent crops, and they are both subject to taxation under 13-101.
Correct.
But under this interpretation, if you consider permanent crops to be improvements, then you effectively have two massively different
Absolutely.
Tax treatments of two different types of agricultural crops with nothing in the statute which
Correct.
suggested that was intended.
You just made my argument. My argument is there is nothing in the statutes, nothing in the Arizona case law, nothing anywhere in Arizona that says we value permanent crops, i.e. nuts grown on trees, differently than we grow peanuts grown in the ground. We don't value vines that produce grapes any differently than vines that produce tomatoes. They're both produced on vines. There's a case, they even cite a bankruptcy case about cranberries, which I didn't know are grown on vines too. But so my point is, it doesn't matter how the crop is grown. We deposed DOR people and the assessor and repeatedly said, do you make any differentiation between the crop? In other words, what if you've got a lease of alfalfa? Alfalfa, by the way, is the most profitable crop in Arizona. It's also perennial for whatever their manual is worth. You don't replant it every year, you cut it. And alfalfa uses a lot of water, but it's a very profitable crop. And yet we don't differentiate between alfalfa and cotton in how we value them.
Is that considered a permanent crop, alfalfa?
It's not. I asked that question of the assessor and I said, well, alfalfa is a perennial. Do you value that the same way you value orchards and vineyards? And he said, no, that's a field crop. And again, we're drawing a line that's meaningless. We're basically drawing a line in the dirt that says, quite literally in the dirt, that says, certain crops are going to be valued one way and other crops are going to be valued differently. That, I think, should make everyone a little nervous.
Well, what is the, I don't mean to interrupt, but I know their time is going down. What's the impact of ARS 42-12-002? That's the one that has the class 2
Correct.
property consist of. And it says real property and improvements to property that are
Correct.
used for agricultural purposes, and that they're valued either at fair full cash value or pursuant to
Correct.
what we have here, 42-13101,
12
as applicable. And I guess I gather, at least I thought what they were saying is that if you have permanent crops like the trees, the vineyards, whatever, that those are improvements. And that was in the manual too. That's improvement to property. So could you address, does that
Sure.
have any impact?
That's one of my favorite quotes is from Lewis Carroll's Through the Looking Glass. I use words to mean exactly what I want them to mean, nothing more, nothing less. And you can find words in the manual, nowhere else, that say permanent crops are to be valued as improvements. There's no Arizona law on that. There's no statute, no case law, nothing. You're absolutely right. And back to Justice Lopez's question, it's important to understand in Arizona, we have a fairly complicated property tax system. We start with classification of property first. We classify property. That enables us to put it in categories and value it in a particular way if we choose to. There's only one classification here that's at issue, which is agricultural. It's the part of class 2 that's agricultural property. By the way, class 2 also covers vacant land, but that's not agricultural vacant land. That's just vacant land that's being held. My point is class 2 classification has never been an issue in this case, ever. It was stipulated at the outset that these are all agricultural properties. From there, you then turn to the valuation statute. And the valuation statute tells you how to value agricultural property. And that valuation statute does not differentiate between permanent crops and field crops, ever, anywhere. So technically, you can have those provisions in the law about classification are all meaningful, but what they're mostly meaningful for is they dictate what assessment percentage is used under the law to calculate the tax bill. For example, the Class 2 property is assessed at 15% of its value, whereas residential homes are valued at 10% of their value. In the old days, when I started, this will date me, the utilities were valued at 60% of their market value. They aren't anymore. They're now on a different scale where they're in the same class, Class 1, which is, as of today, has now descended to 15%. That's what classification has to do with. By the way, you can appeal your classification, or you can appeal your value, or you can appeal both. This case is only about value.
Under 12-151-2, the presence of permanent crops is the feature that qualifies land as an agricultural real property. Is it unusual in tax law for example, a qualifying feature, the presence of permanent crops, to also be considered an improvement for taxation purposes?
Well, I have found no law that says that anywhere in the country. Where it exists, that permanent crops are treated differently, it's by statute or regulation or some law. That is not true in Arizona. But my other point to you would be, in a classification statute, they're setting forth requirements that you have to meet to be classified as agricultural property. They made a differentiation between field crops and permanent crops, presumably based on the intensity of the uses of those types of crops. So they said you got to have at least 10 acres to be a permanent crop and qualify. You have to have at least 20 acres if you're just field crops. I view that as simply a legislative effort to avoid hobby farms and people who might, otherwise come in and say, well, I got fruit trees in my backyard, or something like that. And again, it's just a size requirement that's related solely to classification. I see my time is up. Unless you have other questions for me, I will yield my balance of time
Great, thank you, Mr. Mooney.
to Mr. Souza.
Okay, Mr. Sousa?
Okay, thank you again. I'm Mr. Sousa. Let's start with the full cash value definition. Once again, this is the same problem in the Court of Appeals. You start with a focused approach instead of going to the general approach. When does full cash value matter? When you look at what is the assessor's job to determine the full cash value of all real property in the county. Real property is land and improvements. Then we have full cash value, and the statute does in fact read, if there's a methodology provided by in statute for determining full cash value, go to that immediately. There's your carve out. Do we have that? Absolutely. We have it for things like centrally valued properties where it's all done by statute. We have it for things like common areas and golf courses where it's all specified by statute. If you meet the requirements for being one of those, you get to use those statutes. Do we have it for any other? We do. We have for agricultural property. And when we get down that road, we look at land. And that's what 13-101 and 102 do. They look at land. So how do we do the land? We use the formula. But if it's not the land, and folks, there's a difference between land and improvements. Nobody wandered down the corner and there were 40 acres worth of trees planted. Somebody had to put them in 7 years ago to get the first orange off that tree.
Councilman, let me ask you a semantic question there. The way that you've described permanent crops just now and the way I see it in the briefing, it's almost as if it's being discussed as these permanent crops improved the land versus they qualify statutorily as an improvement.
Fair enough. Let me avoid a word game for you. And this is a game that's been played quite a bit. We have permanent additions to the property called trees. After 7 or 8 years, the trees produce a crop. So the crops are then sold by the farmer to make money. We're valuing the permanent addition to the land of trees. We're valuing the permanent addition of land to sheds. There is no difference at all between those two. They're both added to the land by the farmer. And our statutory scheme says the general rule applies to improvements to real property, and that is standard appraisal techniques.
Let me pause you right there, though, because I feel like this is sort of circular, because we've got to look at the fact that there are permanent crops to define as agricultural real property. Agricultural real property includes land. Land would therefore include permanent crops, but for the fact that we treat them as an improvement.
All those things are true. We treat them as an improvement because the statute is focused on how do you value land. And we take the carve out and use it when appropriate and give them your 99.8% discount. But then we look at the improvements and we add those individually using standard appraisal techniques because improvements are not land. And once you stop at that point, it all makes sense. All the improvements have to have a separate value. The land has to have a separate value because we have a carve out. That's the end of that. This is an important thing that was said. There is no evidence the department produced that there were no leases of completed farms and orchards. Well, actually, when we deposed Mr. Cook, who is the plaintiff's representative, item of record 41, Exhibit B, page 8, Mr. Cook was asked, do you know of any leases where it's a completely done deal, all the trees are planted, producing, and then they lease the property? He said, nope, can't think of any. Well, there are never going to be any. Millions of dollars go into putting saplings into the property, 7 years worth of care. Then the tree is mature enough to produce a crop. At no point is somebody going to turn the keys over to anybody else. And as a result, you will never see that. So the only way that these actually get valued as improvements is by the way the assessor did it. I agree with counsel. When the department's manual said it's $500, $200 an acre, whatever it was, it's nickels and dimes, and nobody protested. But the key is nobody disputed the methodology that was being followed, which was a separate land value and then adding something for the fact that you had permanent trees that were going to produce crops. Nobody disputed that until the assessor said, actually, it's $250 now. The irony here is that they loved the manual when it said $20 for a tree, or $12 for a tree, $200 an acre, $12 for a tree. They love the manuals. But now that it says $250, the manual is the devil incarnate. Bad manual, terrible to have it, not representing the law. In the earlier argument today, we talked about separation of powers for a moment. Let's talk about separation of powers. The legislature passed this statute and said, go out and do the valuation of all the property. They entail the executive branch, which is the department and the assessor, to go do that. And manuals were put in place to say, please do this uniformly throughout the state. So in the Court of Appeals below, the Court of Appeals said, who cares what the executive branch did? Who cares what they've done for 40 years? We've got a different interpretation of the statute. That's a great injustice to the executive branch. Their job is to go out and enforce the laws. They have done it through the manual at the department, and the manager of the department was loved by the farmers when it said $12 a tree. But now that it's $250, because the assessor said it's $250, which they don't protest as exceeding fair market value, now we've got a problem. We don't have a problem. We've never had a problem. Land gets a carve out, it gets a gonga deal, the improvements have regular value standard appraisal techniques, and it turns out that a tree that's producing crops is worth $250, and that's what they should be taxed on. We'll talk about tax for a second. No one's going to pay tax on these amounts. I mean, the Court of Appeals correctly pointed out all taxes are imposed on limited property value, which can only go up 5% a year. So any notion that you've raised my value 2,000%, my God, mom and pop farmer are going to go out of business, fiction. Taxes are going to go up 5% a year. In fact, every person in this courtroom.
You're out of time. If you could just wrap up your.
Oh my God, every person in this courtroom will be dead by the time we even reach half of the increase in taxes associated with the value that were just set. Thank you.
Thank you. Time goes quickly when you're talking about tax.
I know that's sounding true. I apologize.
Thank you very much for counsel and for both your arguments today and your briefing. We'll take the matter under advisement. We'll issue an opinion in due course, and we will stand adjourned for the day.